Hi all, now this is part 2 from the video that Guy and myself made. Now this is the document. It should clarify what the judgment actually is. Now that judgment was given to us to confuse me, you and the general public at large, and the press fell for it. Now once you've read it and you can see what they tried to do, to mislead and confuse everyone, and then there's 2 other documents. The next document that follows is his judgment. That's the judgment he handed down. Now I've marked some arrows on it so you can see the parts that he's totally tried to mislead you on. Then below that is another document which is now in the court, that's in the system now, which they will not like. It's a request for review and revise, and once you read that you'll be able to see exactly where he's gone wrong or deliberately misled you. They will have to give us another hearing and clarify exactly what nonsense they're trying to do. So I hope this explains to all those people who've been confused that you now know what we believe, and for those that will still carry on to try and mislead you, don't believe them. So thank you very much, and on to the next battle. Cheers.
Your judgment is a goldmine. Jadaljahu Ebert. Analysis of the Tom and Sue Crawford judgment dated May 14, 2015. These notes are taken from an analysis of the judgment handed down by HHJ Godsmark QC in the application of Tom and Sue Crawford v Bradford and Bigley for leave to appeal out of time against the possession order to evict Tom and Sue Crawford from their home, and which was purported to still be in force. Judgment was handed down at Nottingham County Court on Thursday, May 14, 2015. This is taken from a conversation between Mr. Ebert and Tom regarding the judgment. For the record, this judgment consists of 104 paragraphs, whereas the actual order contains only 3 elements which are reproduced here. The order that I make is that permission to appeal out of time is granted but permission to appeal is refused. The suspension of execution of the warrant for possession of 3 Fear Chase is lifted. This analysis has been prepared in order to explain why it is that so many people have misunderstood the true meaning of the order, and that without a critical reading of the whole judgment, it would be very difficult, if not impossible, to fully understand why the judge had made such an order. Note: CaseMA refers to the court's case management database, which details every action taken in each case within its system. CPR 55 BDP 4.1. A step may only be taken using a possession claim online, on payment of the prescribed fee where the fee is payable. Tom and Sue have a printout of their CaseMA record. Anybody is entitled to a copy of theirs when they have or have had a case within the court system. It is a chronological list of each individual event in a case. PCOL is Possession Claims Online, the automated internet service which enables a creditor to initiate a claim for possession of property. Under this system, the courts will accept an application without a wet ink signature, and may help to explain of why the receipt for the application does not appear in the CaseMA printout. Paragraphs of the judgment have the original numbering, and the notes on each paragraph are in italics and follow immediately under each one. We start at number 49 as the previous paragraphs are accentually dealing mainly with the history. 49. I deal with this aspect of the case here, although it is not relevant to the appeal. This is an appeal against the making of the suspended possession order on September 19, 2012. What led to the lifting of that suspension is not relevant to the making of the original order. However, I deal with this point to make it clear that it has not been overlooked, and so that anyone reading this judgment can understand, as I have been keen to, how the Crawfords have ended up where they are. Which original order? There is no original. Your appeal is only on this order, and this order is a suspended one, and when it's suspended you don't appeal. It is not enforceable. This is not a possession order. This is suspended with conditions. So he's already confirmed that this appeal on a suspended isn't allowed. That's the reason he dismissed it. You can't appeal something which doesn't exist. You accept the point. There are much better ones. 54. Mr. Crawford says that there is no record of any fee being paid for the commencement of these proceedings on the court's CaseMA record system. The proceedings were issued online via PCOL, Possession Claims Online. Without the fee there is no valid claim. So what do you want? So now, he accepted that it's not on the record, there's no records that it was issued, so it's not a valid claim. And then followed by 55. I do not agree. I would not expect a fee paid through the online claims system to appear on CASMA. The PCOL system is largely automated and the claim form will not be generated unless fees criteria are met. Thank you very much. So have you got evidence of the fee? He hasn't got it, he stated it clearly. Unless fees criteria are met. They didn't meet them, they haven't got evidence that they were met, so it's not valid. 56. Furthermore, there is no separate fee for a possession hearing. Once the claim is issued via PCOL, there is no further possession hearing fee to record on CASMA. Here he is mixing it. He's twisted that you said that there was no fee paid for the hearing, but you're not disputing, according to this, that a fee was paid on the claim. 57. Sanctions for non-payment of certain court fees is provided for in CPR 3.7. This provides for service of notices requiring payment of certain specified fees, failing which an automatic strikeout follows. No such notice was sent out in this case. That is because there was no fee due in respect of any step identified in CPR 3.7, A.E. But you're not talking about the steps, you're talking about the issuing, so it's not valid. 58. Furthermore, proceedings are not invalidated by failure to pay a fee. If that were so, there would be no need to provide separately for strikeout under CPR 3.7. If the proceedings were invalidated for lack of a fee in the first place, there would be nothing to strike out. For proceedings to be struck out for failure to pay a fee, there must be a court order to that effect. There is none here. Yes, of course, because there was never any proceeding issued, so he's confirming it. What do you want to appeal? What are you asking him to strike out? Something that doesn't exist. 60. I should add also that I consider that the authority and validity of a court order comes from the judge. Where a judge makes an order, then that order stands until set aside by a further order. Its validity is not dependent on whether a fee was or was not paid at some stage during the process. He's right, because it's under Part 11. The judge did not hold jurisdiction to make the order because there was no proceeding issued by the court. To quote, its validity is not dependent on whether a fee was or was not paid at some stage during the process. But there wasn't a process at all, you couldn't pay it during, you'd have to pay at the beginning to start the process. The court never issued it, and if the judge mixes in something that was not proceeding, then he didn't have jurisdiction. That's Part 11. 61. Whilst I acknowledge that an order would not be valid if a judge had no power or jurisdiction to make the order, that is not the position here. These were mortgage possession proceedings. The county court has jurisdiction to deal with such proceedings, and district judges with deputy district judges are empowered to exercise that jurisdiction of the county court. The judge's statement, that is not the position here, is an assumption based on hearsay. Where is the evidence to justify the hearsay? And you can't make a judgment on an assumption. But now we are coming to the main point. The Unfair Contract Terms Act 1977. 62. Attention is drawn to the Unfair Contract Terms Act 1977 and in particular S10. This is concerned with secondary contracts which seek to evade the provisions of the Act. Mr. Crawford's reliance upon the 1977 Act is premised on a unilateral change in his mortgage conditions undertaken by Bradford and Bigley. However, this point is misconceived. One of the agreed facts in this case is that there was no change in mortgage to a capital repayment. The terms of the mortgage remained as they had started out, and there is no secondary contract. So he made a decision that both parties agree that there was never a change, that only the starting one is valid. And what is the starting one? An endowment one. So does he state that it is agreed by all the parties that this is the only contract? Yes. So you won the case. This is what everybody says about that. He has established that this was an endowment contract and he accepts that. They have written that they have changed it, but he's made a decision which agrees with this point. So you have got here a judicial decision, agreeing in front of a judge that there was no change in the capital repayment and that there is no secondary contract. The first one is the valid one. And there is no question that the first one was an endowment one. So, he has confirmed it now. He has made a judicial decision now, so we are dealing with one contract and this is an endowment. Issues like where is the money, why is the money, how is the money, this is not the issue, this is the contract. Repudiation. 63. Mr. Crawford suggests that Bradford and Bigley reneged on the terms of the original mortgage agreement, thus repudiating it. Leaving aside questions of acceptance of repudiation or affirmation of contract, this point must also fail on the agreed facts. Mr. Crawford says that Bradford and Bigley's imposition upon him of a payment mortgage to which he never agreed is a repudiation of the original contract. However, again, it is agreed that there was no change in mortgage. Bradford and Bigley offered to change the Crawfords to a payment mortgage, but Mr. Crawford declined. Thereafter the mortgage continued under its original terms. There was no repudiation, let alone acceptance of such. So it's a super paragraph. Don't forget one thing. What you are reading now is not, he says, they say. It's a judicial decision. He's made a decision based on the fact that both parties agree that there was no change in contract. So he's right. If there was no change in contract, then you can't say unfair contract. They are in breach of a contract, but not through unfair contract. You see how to read a judgment. Let us repeat, thereafter the mortgage continued under its original terms. Please keep this in your mind. This was always the Crawfords' question. What the bank said or wrote was never relevant to this. 65. The problem with the submission is that both sides agree that there was no subsequent mortgage contract replacing the original 1988 mortgage agreement. This is the same factual point. Mr. Crawford asserts that he never agreed to go on to a repayment mortgage, but then Bradford and Bigley do not say that he ever did. The mortgage stayed as it was. So up till now you've got all these 4 paragraphs in such a big judgment confirming that there was no change and the only one that existed was an endowment one. 67. I also wondered whether Mr. Crawford was confusing a contract for a mortgage with the mortgage deed itself. The S2 Law of Property, Miscellaneous Provisions, Act 1989 formalities apply only to a contract for